Welcome, viewers, to Part 4, the final part of the 25th Annual Autumn Estate Planning Seminar brought to you by Chipman, Mizuko, Emerson, a Danbury and Southbury, Connecticut law firm. My name is Richard Land, and I'd like to introduce you to our next presenter, Richard Emerson, who we know as Dick. Dick will be telling us how to prepare for a trouble-free probate. Dick was a probate judge in Reading, Connecticut for at least a couple of decades, maybe more, and is uniquely qualified to guide us through the process of settling estates. This Part 4 picks up where Allison Marcuccio's presentation in Part 3 left off, so here's Dick Emerson and Part 4.
Thanks, Allison, and thanks, Rich. Hope you can all hear me all right. Shake your heads. Yes, good. Well, I'm going to be speaking about some basic issues that clients ask on a regular basis, and they want to know, what can I do to prepare my estate for administration before I die? And I want to understand the process that I'm going to be following, or my estate's going to be following, once I do die. So the question, that's basically the question. And my answer is, well, use common sense. Nobody can really read your mind. They don't know what you want. So let your survivors know what it is that you do want. Now, if I'm the executor, among the things I want to know is, do you want a wake? Do you want a church service? Do you want a reception? Do you want to be cremated? Do you want a headstone? Where do you want to be buried? All of those kinds of questions. And I've had situations where I was the executor and a relative had very strong feeling about what they wanted, and it was completely contrary to what the decedent had told me they wanted. And so as executor, my job is to do whatever it is the decedent wanted, and that's true for any executor. So try to tell the people who are going to be making those decisions what it is that you really want to do. Now, should you have funds available? I mean, do you have a surviving spouse? Do they have funds? Are they going to be able to pay for your funeral? Well, what do funerals cost? It's least expensive way I've seen is you go and get cremated, and there are some local facilities that can do that. I see numbers running everywhere from $3,000 or $4,000 to $20,000, depending on what it is you're going to do. So this is a significant expense. Is there going to be money available? If there's no surviving spouse, is a child going to be able to pay this and then get paid back from your assets in your estate? Or what's going to happen? So you ought to think about it, have some funds available in some kind of an account for a surviving spouse. The surviving spouse can have separate accounts, can use their own money. They can be repaid from the assets in the estate. You could have a joint account. If you have that, that's probably the easiest. If it's a surviving spouse, they can pay the bills. So what does the executor need to know after, once you've died? They need to know what your assets are. Where are they? What are they? And remember, if you do set up a joint account, that joint account belongs to the joint owner. It does not pass under the terms of your will. And a lot of people say, well, I did a will, and so therefore everything's going to pass equally to my children, except I put all my assets in a joint account with one of the children. And that obviously can lead to lawsuits, disputes, nobody talking to each other for the rest of their lives. And so you want to avoid those kinds of things. I have clients that say, well, I have one child with a power of attorney. They're going to be able to handle my assets. They'll pay the bills after I die. Well, no, that's not going to work, because a power of attorney terminates at death. So that's not going to work either. Now, I would recommend that you organize your assets and your expenses. And you'd be surprised how many people come into the office, children and surviving spouses, and really know very little about the assets of the decedent. Don't know much about the debts. All the decisions, all the bills were paid by the person who's now the decedent, and the survivor really knows nothing. So I would recommend you tell them where the assets are and how they can access them, and how they're owned. Now, I'm kind of old school, so I actually get paper copies of all my statements. And I recommend, I mean, a lot of people disagree with that, but that's, I think, the easiest way. And I know they say, well, what do you do? So my answer is, well, for every account that I have, I keep a notebook. I put the monthly statements, quarterly statements in those notebooks. I line them up on a shelf. And once a year, I bring my spouse in and say, here, look at these. And in 5 minutes, you can see exactly what I own, how I own it, who the beneficiaries are. But not too many people do that, but I certainly recommend it. I also prepare an annual financial statement on December 31st showing all my assets. And I put them in a separate file and they can see every year what the assets were. And they can identify fairly quickly in 5 minutes exactly what I own. And you'd be shocked really at how long it can take me, if I'm either the attorney or the executor, to figure out the assets that belong to that individual. It can take months, it can take a year before I even figure out what the assets are. And it's not that hard for you to prepare in advance and make it easy for your executor and for your children. Now, we talked a bit, well, some people like online statements and they say, well, I'm being silly by getting paper copies. I'm wasting trees. I'm doing whatever. And that's okay, but make sure that whoever is going to be handling your estate knows how to access those records. What are the passwords? Where are the accounts? Where are they held? How do you access them? What's your identifier? What name is the account? What are your passwords? And those can get pretty tricky because I can't keep track of all my passwords. I must have 1,000 of them. And I always have to look them up every time I need one. So at any rate, that can be a problem. Now, for assets with beneficiary designations, everybody else has covered the problems that you can run into with them. But what you should do is make sure you know who they are. So at least you can talk to your attorney about who they are and make sure that they're up to date. I've had estates over the years where life insurance policies, the decedent's been married for 40 years, but the life insurance is still payable to his mother, who is still alive. And so what happens to that? Obviously, it's going to go to whoever the beneficiary designation is, and it may not be at all what you want, particularly in the years when the banks were all going out of business, merging and changing. I ran into all sorts of problems for beneficiary designations because when they merge, they do an information dump, but they miss beneficiary designations, and people would swear to me that they did a beneficiary designation, but the surviving bank couldn't tell them who it was, or they had a different name or whatever. So check your beneficiary designations and make sure they're up to date and they are what you want. So another issue you might think about, and I won't get into it in any detail, but RMDs are required minimum distributions. As a beneficiary, you might be required to take that RMD in the year of death. A lot of people do their RMDs in December of each year so that they can get the growth that's attached to those assets throughout the year. And if that's the case and you die before that RMD, you might be required to take it. So take a look at that issue. Income taxes. What do you do about your income taxes? Now, for the year of death, assuming you die, you don't die on December 31st, you're going to file, whatever you die, you're going to file an income tax by April 15th of the year following the year of death. And what do? How do you keep records? How do you make that information available to your beneficiary or executor? Again, I've got one right now where I'm having a heck of a time. The IRS has a completely different opinion than the surviving children do about what was paid. And these days, the IRS is not responding that quickly to your requests. And so if you don't have bank accounts, if you can't go back through every statement and figure out what the payments were that were made, that can be a problem. So provide those records. Now, I don't know what most of you do, but I would recommend that you keep a file for each year, and that in that file you have a separate sub-file for all estimated payments that you've made, a file for any tax information, any charitable deductions that you're going to take, and keep track of those things and make them available. So it's simple for somebody to figure out your income taxes for the following year. Now, you might also want to make it available to your executor and your beneficiaries. What are your debts? What has to be paid? Now, an easy way to do that is your check register. Now, if you keep a check register and you got every check and you have one account, it's pretty simple. Anybody in a few minutes can figure out exactly what you paid through the year. And they can figure out what your debts are by looking at the last couple of months. But I can't tell you how many times that's not the case. Like, I have a check register and it's a mess and I can't make any sense out of it. I can't even figure out what year it is. You know, I think it's the current year, but it's not. It's some prior year. So make it easy for people. Also, keep the bank statements for the past year. And what kind of bank statements? Now, a lot of the bank statements I get, they have numbers on them, so they show a dollar amount. But what good does that do me if I don't know who it was payable to? So I always recommend people get bank statements that show you pictures of your checks. That will make it much easier for your executor, your beneficiary, your children to make sense out of what you've done. Now, how can you do it if you haven't done that? Well, I can look at your mail, or your executor can look at your mail, your beneficiaries can look at your mail, and figure out over a period of time what it is that are your assets, because you should be getting account statements, assuming you're not getting them electronically. And you should be able to get statements that show assets. And over the years, I've had situations where I discovered significant assets after the death of the individual by just reading the mail. Now, you can go online with the post office service and have the mail forwarded. Now, that generally is just for 6 months. So hopefully you can find out what you need to know within the 6 months. But again, if you keep these records and make them available, it will make it much easier for whoever's handling the estate. I found, and I think I had Jim work on one estate where we found jewelry inside a book that had been hollowed out. Strange things happen. We found stock certificates behind the shelves. We found all sorts of things, but organize your assets and make a summary of all those assets available. Make it a lot easier. Now, what about tangible personal property? What do I do with that? Well, most people vastly overestimate the value of their tangible personal property. These days, it costs you money to get rid of your tangible personal property. You have to get a dumpster and throw it all in because nobody wants it. The charities won't even accept stuffed furniture. And the stuff that I like, which is now called brown furniture or antiques, is worth a third of what it was 30 years ago. It's just not bringing the prices. Now, I have to be careful because one estate that I had, one of the most valuable asset I had, I would have probably given away for $10. They were Indian blankets from the 1800s, and they were worth a lot of money. And if I hadn't had an expert look at them, I would have been clueless. And that's coming from someone who watches Antiques Roadshow constantly. But I didn't know what they were worth, and I think most people wouldn't know. So you have to be somewhat careful because you don't always know what things are worth. Particularly with regard to paintings. Every time I watch Antiques Roadshow, I look at a painting, I say, that's ugly. I'd never hang it on my wall. They say it's worth $150,000. And I go, what? How am I never would have guessed that. So you got to be careful. Now, if you want certain individuals to have items, you can do a memorandum under your will and give it to them. You can put it in the will. If it's a memorandum, it's not necessarily binding, but I find in most cases, not every case, people will agree that's what mom or dad wanted and that's what we're going to do. That's a simple way for you to do it. Now, if you put it into the will and then you give it away before you die or the asset goes missing, that can create a controversy as well. Everybody accusing each other of running off with the assets just before mom died. So think about your tangible personal property, discuss it with your children, make sure they understand who gets what, and that will go a long way to avoiding disputes after you've died. Now, again, I guess in summary, some advanced preparation will save your executor, your children, a lot of trouble. Now, what's the most important step you can take in order to administer your estate? Well, you should have a will. If you don't have a will, then you're intestate, and the first 100,000 goes to the surviving spouse, and the balance is 50-50. If the children are not children of the surviving spouse, then it starts 50-50 from the first dollar. Now, I've talked to a lot of clients over the year, and I've never found one that thought that was what they wanted. So you ought to think about what you want to do. You spent your whole lifetime building up assets. Take a few minutes and figure out what you want. Now, let's assume that we have a will and you're meeting for the first time. And what do you need to know? Or what does your attorney need to know? Well, he needs to know what your assets are and how they're owned. Are they solely owned, jointly owned? Are they payable on death? Is there a beneficiary designation? Now, what's the difference between a probate asset and a non-probate asset? Well, a probate asset in general is solely owned. It's not joint, it's not payable on death. It has no beneficiary designation. And those are the things that pass under the terms of your will. And I mentioned it earlier. Don't take all your assets and put them joint with one child when you want everything to be split equally between the 4 children. So be careful. Now, once we figure out what your assets are and how they're owned, what is it that we do? Well, they can have a tax purposes only estate, which means everything passes directly to a beneficiary. It's joint or has a beneficiary designation. In that case, we have to file a will for informational purposes, and we do a tax return. Next one would be a small estate. So that's 40,000 under. Oftentimes the ones that I see, it's because everything was joint, but maybe there were 2 cars that weren't joint, and we have to take care of the cars. Now, as an aside, they now have a section on the title for your car in which you can make them joint. You can designate the cars as joint. We'll avoid having to worry about a small estate. Or the next step up is a regular or full estate, and that's mostly what we have as far as estates. Now, sometimes you just need to open a full estate so that you can get a fiduciary certificate so you can figure out what the assets are. Because nobody will talk to you if you just call up and say, I'm the attorney for Joe Schmo, or I'm the child. They just won't talk to you. They won't tell you anything. So you might need to get appointed just to find out what's in the estate. Now, generally, you need to open an estate checking account because you're probably going to end up with some checks payable to the estate. You're going to have nowhere to deposit them. If the bank knows that the person is deceased, they're going to shut down that account. And even if they don't, they're not going to accept a check payable to the estate of into an account in an individual name. It's going to reject it. And so you're going to be stuck with money and don't know what to do with it. Now, what are the steps at the probate court? Now, they are, first, we file an inventory. And our inventory is just a list of whatever the assets are that were owned at the date of death. And those are the probate assets. They do not include the non-probate assets. The next is a return of claims. And that's a statement of all the debts that existed at the moment of death. So those are pre-death claims, things that existed before the person died, not expenses that arose after the date of death. After the date of death, those are called administration expenses. And then, of course, we have tax returns. We have an estate tax return. We have an income tax return that I already mentioned. The estate tax return in Connecticut is due 6 months after the date of death. We can get extensions for that. Now, I'm assuming non-taxable because a lot of the states that were taxable a couple of years ago are no longer taxable. And then we've got the financial report, which is basically what did I start with, what did I spend, and what do I have left and who gets it. That's basically what goes on to the form. And then if we have any kind of a reserve in the financial report, we'll have a closing affidavit that just says, what did we do with the last part of the money? But I guess in general, my advice to people would be keep careful records, keep copies of all checks. If you're the executor, Make sure you keep copies of all the checks, all the bills you paid, all the claims. The claims or administration expenses. Now, everybody else already mentioned what the tax thresholds are, so I won't repeat them, but they're high enough now that most people aren't going to be taxable that we see. Certainly not everyone, but a lot of the estates. Now, how long does it take to do all this? Well, I guess a normal estate takes, if we don't have any problems and we're not taxable, the tax return's not due for 6 months. So usually it's something like a year before we finish. And if we have a taxable estate or complications, it can be 2 years or more. Now, one of the things that you need to get is a lien release for the real estate. If you don't go through the process, you're not going to get a lien release, and you're not going to be able to sell your real estate because the buyer is going to be looking for that lien release in order to purchase the house. Another question would be, who should be my executor? Well, most cases, it seems to be the spouse, and then the spouse can hire someone to advise them with regard to how to administer the estate, somebody like us or other people that do what we do. And people ask me, well, is it an honor to be an executor? Well, the answer is yes and no. They trusted you because they appointed you as the executor, but it's a significant responsibility, and you can get yourself in big trouble if you don't follow the tax rules in particular. So I guess in summary, and I think I'm out of time at this point, I would say good luck and let us know if we can help you in some way. And with that, should I turn it back to you, Rich, as our moderator?
Can I ask a couple of questions? I promise. Sure.
As long as they're not too complicated, sure.
Well, no, actually, one's more a comment, one's a question. When you first started, you were talking about kind of funeral arrangements and cremations and things like that. I was just wondering, to what extent, when you were a probate court judge, did you get involved in quarrels or disagreements about what to do with the remains of the deceased?
Well, I thought I would get involved in quite a few, but over the years, I've had very few. People, and usually it was driven by the fact that there was some relative who thought if they had possession of the body, they controlled the assets, which of course is not the case. And so when I explained that they could have possession of the body, but they were going to have to undertake the expenses of dealing with that, they suddenly disappeared and they left. So I actually had very few times where I had to make a decision about who had custody of the remains.
In non-traditional family types of settings, just having a document that appoints somebody to have custodian of the remains, I think can deal with a lot of problems that might otherwise arise.
Right, and there's a form, a cremation permit, self-directed, and we do that for quite a few clients because the relatives may not agree with it. If you want to be cremated, you should fill out one of those forms.
I also think that if you have a situation where you think there could be a problem, particularly in non-traditional families, that I encourage them to go to their local funeral home and do a pre-need assessment and arrangement. They don't necessarily have to pay right then and there, but at least they can make their wishes known. And
Right.
by and large, they do.
Right, good idea.
And the other thing that occurred to me was when you talk about records, spend a lot of time on records. Of course, the accountant is a good source of information when it comes to assets and income and all. And I meant to make the point when I was making my presentation in running through all the options with respect to when to take your IRA distributions and calculating the tax brackets that apply and just all the different permutations. You really need a good accountant. I didn't want to create the impression that I'm the guy to go to for those types of things. I've discovered that I probably create much more work for accountants talking about these complexities than I do for myself. So accountants can be a big part of trying to solve the puzzle.
Right. Yes, I usually ask for, but I have to say I can't always get them. People can't find them. We threw all that stuff out. We only keep it for a day or a week or a month. And so at least if I know who the accountant is, I can sometimes go and get the latest tax return. You can look at if I'm searching for assets, I look at all of the dividend statements. And then I track those down to find out if they still own them at the date of death. If they didn't sell them between the last tax return and when they died. But yes, I agree. That's a good source of information.
For those of you out there viewing, I thank you for viewing. And I think I forgot some important information. We are members of the law firm known in Connecticut as Chipman, Mizuko, Emerson. We're a law firm where obviously you see the 4 members in the trust and estates area, but we have lawyers doing work in business law and land use and litigation that is related to those matters, and a broader range of things than that. So I don't want you to think that we're the only ones at the firm. We've got a lot of folks who can help when you need that type of legal assistance. Anybody else have anything more to say?
Shall I stop recording?